Any other questions before we move on to board discussion? Director Kilkenny.
A couple questions for staff, if I might. Ms. Collier, in her testimony, made some observations about, I didn't fully understand it, but the commercial use on the ground floor conflicted with uses that were otherwise permitted. Staff, would you like to respond to that?
I think her testimony was that what she viewed as a doubling of the event space would cause undue problems for the neighborhood. Currently, the open deck area, I think you're familiar with, there are a number of events held there now. They're in the outside. Those events would now be held on the interior of this building, since the open courtyard would be greatly reduced. So we would anticipate there'd be reduced noise. However, there would be, accessory traffic, pedestrian and vehicular in the neighborhood from events occurring in there, just like they do currently.
A second comment that was made was that given the parking configurations, it would be unworkable for catering trucks.
Depending on their size, of course, there is a space within the garage that's been allocated for parking, for loading, and for type of catering. It depends on the catering truck, whether or not they would be able to access that readily.
We've heard at several different instances concerns about potential earthquake faults. What is the proper venue and permit authority for dealing with that question?
Again, the city's geologist reviews all structural, all fault investigations, and must sign off on them before any building permits are issued.
Okay. And then our role, the action that we're asked to do today is design review, correct? We are not a permit issuing entity.
Right, you're not a permit issuing entity. This is a fairly unique process because of the agreement affecting real property that it requires redevelopment agency approval in writing. So we are recommending not only design review approval, but overall project approval under that agreement.
And then one additional thought, or a question that I had that I forget whose testimony sparked this in my mind. Could the applicant, when they did the condo conversion, if they weren't doing a condo conversion, given the fact that they had 14 legal lots on the site apparently, could they have gotten a lot line adjustment which would have created parcel 2 without going through the discretionary process that's associated with condo map?
Yes, it would typically be an administrative process, filing of a parcel map and or lot line adjustment to create two legal lots out of the existing 12 lots on the block. Assessor parcel numbers, as I think you're aware, are not a description of legal lot. They're a description of ownership of property and not legal lot status.
But the answer is yes, they could have gone through a lot.
Yes, they could have done it administratively without the condo conversion. That's what triggered the need for the tentative map.
Okay, those are my questions.
Let's move to board discussion if we could.